here with us, Honorable Advocate General of Kerala, Advocate K. Gopalakrishna Kurup. He is the guest of the day. After all, the speaker of the day is one among our family members. He doesn't need much introduction. Not that, I am competent of introducing an Advocate General. I was looking at the Constitution of India. As per the Article 165, the governor of each state shall appoint a person who is qualified to be appointed a judge of High Court to be Advocate General for the state. So, we have a judge, not only an Advocate General, he is also judge of the High Court. It shall be the duty of the Advocate General to give advice to the government of the state upon such legal matters and to perform such other duties of legal character as may from time to time be referred or assigned to him by the governor, and to discharge the functions conferred on him by or under the Constitution or any other law for the time being in force. The Advocate General shall hold the office during the pleasure of the governor. The pleasure of the government is very important these days. And shall receive such remuneration, etc., etc. It goes on. Those who are, I know this is something very much common knowledge for all our lawyer friends. Quite many are here. But as an economist, something which is it's a new knowledge for me. And I'm extremely happy that Honorable Advocate General is here, because we are living in a world foreign, all what government does and all what government doesn't do, government is dragged to the court. So I think our Advocate General must be one of the most busiest person these days. And I don't know how he managed to kind of take the time over to be with us. I'm sure, despite his long innings, I think he started his career in 1976. Quite many years, many of you people around were even God even not even planned about you. He started the profession, and he is now holding this important position. He managed to be spare time with us. I think that should purely be an indication of what is called the academic mind that he has, the mind to learn. I think a person of his stature and responsibility, he cannot afford not to be learning. So I think, sir, we are extremely happy that you have joined us. And on behalf of the whole GIFT community, I warmly welcome you. Give me a big applause. Now, coming to my great friend, Mohan, for the fresh batch, I think he's going to take some classes for you. He belongs to Kejriwal's batch, that category. So you should know that he's a very dangerous person. So, and again, I have some interesting civil service persons whom I considered credible. They all resigned. I'm talking about Bala, he resigned at the age of 30. Sorry, not Bala. I should not be saying Bala. Sri Bala Gopal, who was who resigned in the early 30s and started Therimapenpol. And now this is a 1,500 people employing company, the second largest, tied with Thermo in the US. And he bought the technology, a homegrown technology, and made it big. And today, more importantly, he is the only person who professes, which some of my colleagues doesn't like, I suppose, don't agree. He professes the only person with Kerala Todu Kurala Ore Victi Adaham. Industry is possible in the state, he says, and I like him because of that, whether you like it or not. And only thing is, Mohan also resigned a bit later, that's all. And coming to his academic credentials, he was formerly, I won't tell everything because he did his MPhil in CDS and I was there to select him for the PhD. I didn't teach him, I was in JNU at that time. And when I selected him, in fact, in that committee, I told this person is going to submit this in 2 years' time. But he didn't join. And then I happened to read, that those days I used to read everything other than those relating to public finance. So I never read anything that he wrote those days. He has a number of working papers in the Center for Development Studies. He has prepared the memorandums for various finance commissions and so on and so forth. And he has a very interesting book. All of you must read the book with Dr. Isaac on fiscal federalism. That is a book that I first read of you. I really got really impressed, and Suhai is now trying to kind of build on to that. So because I know that I'm not the person who is giving seminar. I was only trying to complete that 4:30 time. It's already 4:30, so it is time. I think anything beyond from me, you will not tolerate. I know it. So, G, I welcome. I must welcome you, even if you are a regular member. With these words, I request the Honorable Advocate General, Advocate K. Gopalakrishna to chair this session and conduct the proceeding. Over to you, sir.
Professor Sri K.J. Joseph, Director Gift, Sri R. Mohan, Speaker of the Day, Sri Dr. Kiran Kumar, Seminar Coordinators, participants of this seminar who have joined this seminar online and offline, and all the dignitaries joined by online, offline. Dear friends, ladies and gentlemen. First, let me express my thanks to the organizers of the seminar for inviting me to chair this seminar. And I express my great pleasure to join you on this occasion when you organize this seminar on the current topic. Now, let us start the seminar as scheduled. Friends, the subject, Center-State Relations in India, Constitutional Provisions and Role of Constitutional Functionaries, is in the current situation is a topic of national importance and national debate. Let us have a look at the different provisions of the Constitution and to understand how the framers of our Constitution have thought, or while giving us the Constitution, the final form, thought of the structure of the political structure of our country while framing the Constitution. Article 1 of our Constitution proclaims India, that is Bharat, to be a union of states. That union was not of sovereign and independent states which decided together to form a federation. In fact, the constituent states of union themselves were creation of our Constitution. As such, India cannot be said to be federal in the traditional concept of federalism. Our federalism is also not territory related, as is evident from Article 3 of the Constitution, which enables the Parliament by law to form new states or to alter the areas, boundaries, and names of existing states. A conspectus of many of the provisions of our Constitution makes it discernible that despite having appearances of a federal structure, it's more unitary in character than federal in nature. However, this does not mean that states are mere appendages of the union. In the sphere allotted to states, the states are supreme. The union cannot tamper with the powers of the states in the central levels. As held by the Constitution bench of our apex court in Government of NCT of Delhi versus Union of India and another, I quote, our constitution contemplates a meaningful orchestration of federalism and democracy to put in place an egalitarian social order, a classical unity in a contemporaneous diversity, and a pluralistic milieu in eventual cohesiveness without losing identity, unquote. The federalism in our constitution is in its form and the unitary in its spread. Our federalism is not a matter of administrative convenience, but an outcome of our own historical process and recognition of the ground realities. In S.R. Bombay versus Union of India, federalism was held to be an essential feature of our constitution and part of its basic structure. Part 11 of our constitution envisages a relation between the union and the states. Chapter 1 thereto, comprising of Article 245 to 245, deals with legislative relations, and Chapter 2 thereto, comprising of Articles 256 to 263, deals with administrative relations. The Parliament can make laws for the whole or any part of the territory of India. Parliament can make extraterritorial legislations. Article 246 of the Constitution provides for the respective fields of the competence of Parliament or the state legislatures to make laws. The fields of legislation earmarked to the Union and the states have been enlisted in Schedule 7 to the Constitution as List 1, List 2, and List 3. Unions list, state list, and concurrent list. Entries in the state list are those regarding which state can alone make laws. Entries in List 3 are those matters regarding which both Parliament and state legislature have concurrent powers to make laws. The function of the three lists in the 7th schedule is merely to demarcate legislative fields between Parliament and states. Article 246 only empowers the Parliament to legislate on the entries mentioned in List 1, List 2, and List 3 of the 7th schedule, and that in case of a conflict between a state law and a parliamentary law, under the entries mentioned in List 3, the parliamentary law will prevail, subject, of course, to presidential assent envisaged under Article 254. It does not follow that the Parliament has a blanket power to legislate on entries mentioned in List 2 as well. As per Article 254 of the Constitution, a legislation made by a state legislature in relation to a field of legislation enlisted in List 3 of Schedule 7 will override a legislation made by Parliament with regard to the same field if presidential assent have been obtained for the state legislation. The Parliament had been vested with residue power of the legislation. This is that is with regard to any matters beyond the fields of legislation enlisted in the three lists of Schedule 7. As per Article 249 of the Constitution, the Council of States has declared by a resolution supported by not less than 2/3 of the members present and voting that is necessary or expedient in the national interest that the Parliament should make laws with respect to any matter enumerated in the state list. Then, on passing of such a resolution, Parliament can make any laws for the whole or any part of the territory. Such resolution will have force for a period not exceeding 1 year and can be extended for a further period of 1 year by a further resolution. The Parliament can also legislate on a state subject if the legislatures of 2 or more states resolve that it is lawful of Parliament to make laws with respect to any matter enumerated in the state list relating to those states. Thereafter, any act passed by Parliament shall apply to such states and to any other state which passes such a resolution. The Parliament also reserves the right to amend or repeal any such act. The President can authorize the Parliament to exercise the powers of the state legislature during proclamation of President's rule in a state. Likewise, Parliament can legislate with regard to fields of legislation mentioned in the state list while a proclamation of national emergency is in operation. Article 256 of the Constitution mandates that the executive power of every state shall be so exercised as to ensure compliance with the laws made by Parliament. The executive power of the Union shall extend to giving of such directions to a state as may appear to the Government of India to be necessary for that purpose. Article 257 mandates that the executive power of every state shall be not impede or prejudice the exercise of the executive powers of the Union. And executive power of the Union shall extend to giving such directions to a state as may appear to the Government of India to be necessary for that purpose. The Union government can issue direction to the state government even with regard to the subjects enumerated in the state list. Article 263 provides for provisions with respect to interstate council for better coordination among the states. Article 268 to 281 of our Constitution are provisions governing financial relations between the Union and the states. It includes provisions with regard to taxes levied by the Union, but collected and kept by the state, taxes levied and collected by the Union, but assigned to the states, taxes levied and distributed between the Union and the state, statutory and discretionary grants in aid from the center to states, and sharing of proceeds from other taxes. The 101st Amendment to our Constitution and the consequential introduction of GST regime has brought about significant changes to the financial relations between the Union and the state. The Indian Constitution, though federal in structure, is modeled on British parliamentary system. In the Westminster form of governance, the king is the figurative head of the executive, comprising of elected representatives who represent the will of the people. Likewise, under our constitutional scheme, also, the governor is a figurative head of a state. He is the most important constitutional functionary in the context of center-state relations. As per Article 154 of the Constitution, the executive power of the state is vested with the governor. As per Article 163 of the Constitution, there shall be a council of ministers with chief minister as the head to aid and advise the governor in the exercise of his functions, except in very limited contingencies where he is, by or under the Constitution, required to exercise his function in his sole discretion. He is bound by the advice of Council of Ministers. The pleasure of the governor in relation to matters which he is not expressly enabled by the provisions of the Constitution to exercise his sole discretion depend on the pleasure of the Council of Ministers aiding and advising him. The leader enjoying the majority in the state legislature has to be invited by the governor to be the chief minister, and the other ministers have to be appointed by the governor in accordance with the advice of the chief minister. The pleasure of the governor with regard to the members of the Council of Ministers constitutionally depends upon the pleasure of the chief minister. Governor is also a member of the legislature of a state. Every bill passed by the legislature has to be given assent by the governor. The governor either can give his assent or reserve the bill for presidential consideration or return the bill for consideration of the House. Though no time frame has been stated in the Constitution regarding the period which the governor has to give assent to a bill, it has to be done within a reasonable period of time. Constitutional silence is not a leeway to create a constitutional impasse. Constitutional functionaries and bodies are expected to maintain mutual respect and comity in their mutual interactions. The legislature as a constitutional body is endowed with the solemn function of making laws, resonating the popular will and the changing needs of the society. Keeping bills passed by the legislature in back burner for long does not augur well for a democratic polity. The Constitution does not require the governor to act as a mere agent of the Union. The governor as head of the state has his functions laid down in the Constitution itself. In Hargovind Pant versus Dr. Raghupal Tilak, The Supreme Court held that the governor was not subordinate or subservient to the government of India, that he was not amenable to the directions of the government of India, nor was he accountable to them for the manner in which he carried out his functions and ties, and that he was an independent constitutional office which was not subject to control of the government of India. On May 3, 1949, Jawaharlal Nehru explained to the Constituent Assembly, I quote, I think it would be infinitely better if he, the governor, was not so intimately connected with the local politics of the province, with the factions in the provinces. And as has been stated by Mr. Munshi, would it not be better to have a more detached figure? Obviously, a figure that is acceptable to the province. Otherwise, he could not function there. He must be acceptable to the province. He must be acceptable to the government of the province, and yet he must not be known to be a part of the party mission of that province. He may be sometimes possibly a man from that province itself. We do not rule it out. But on the whole, it probably would be desirable to have people from outside, eminent people, sometimes people who have not taken too great a part in politics. Politicians would probably like a more active domain for their activities. But there may be an eminent educationist or persons eminent in other walks of life who would naturally, while cooperating fully with the government and carrying out the policy of the government, at any rate, helping in every way so that policy might be carried out. He would nevertheless represent before the public someone slightly above the party and thereby, in fact, help that government more than if he was considered as part of the party mission. This was how the office of the governor was conceptualized by our constitutional framers. The relation between the union and the state government is not of a dominant servient nature, but one of mutual cooperation and inclusiveness. The same can be best attained by continued and rigid adherence to the constitutional ethos by all stakeholders in every perspective. Friends, I made only an attempt just to make a survey of the relevant provisions which govern the center-state relations and the role of the constitutional functionaries in that context. I hope that Mr. Mohan will deliberate on all the issues in his paper or in his speech, which you are there to listen. I thank you one and all, and I conclude. Thank you.
Thank you very much, sir. I think it was a very enlightening address, and I hope and wish in the near future to welcome you physically over here. All the best.
Thank you.
May we invite Mr. Mohan.
Director Dr. K.J. Joseph, Chair of this session, Honorable Advocate General, who has given a very erudite and enlightening summary of the topic of the day. I shall try to run through the issues because each one you can give a seminar separately. So I'll try to run through the issues. Our topic of the day is interstate relations in India, constitutional provisions and role of the constitutional functionaries. Let me start with that. Next. Whatever be the provisions written into the constitution or unwritten constitutions be, on the concluding day of the Constituent Assembly debate, speaker after speaker, and Dr. Ambedkar emphasized that it is men who have a role to play in implementing the constitutional provisions. They can make the constitution, they can mar the constitution. Over the 75 years period, we have seen both. So that happens. Now, the Constituent Assembly debates, India's Constituent Assembly debates ran for 3 long years from 1946-1949. In history, Granville Austin said that after the Philadelphia Convention of 1789, which framed the US Constitution, a short one, our Constituent Assembly debates, they have been legendary debates. The first and foremost thing which, in my point of view, is the most important is that Constituent Assembly members, or the founding fathers as we call them, or the makers of the Constitution, they have placed immense trust on the constitutional authorities. To make a small example, in Article 164 or the corresponding article of 75 of the relating to union, it was said that the president, there should be qualifications prescribed for ministers. Those who are accused of certain cases, they should declare their assets. They should not be involved in cases. Dr. Ambedkar and many other members of the union, members of the drafting committee, they said, it is prime minister or the chief minister or the premier of the province, as they called at that time. It is they who advise the governor or the president to appoint a minister. And public are the watchdogs of our democracy. And we do not think that nobody will make such bad recommendations, though immense faith was placed on the caliber. It was also said that the size of the ministry should be limited. At that time, no such regulation was brought in. They said, leave it to the discretion of the prime minister to have a cabinet of his, how to run the state. Constitution need not. But later on, we made that amendment that 15% of the legislature and parliament, they should not exceed, and in states it should not be below 12. Many other things were brought in. Regarding cases also, the things were brought in. Constituent Assembly also had a long debate on how a governor of a state should be appointed. Because governor is the connecting link between union and the states. It's an important official, sentinel of the constitution. Draft Article 131, initially Constituent Assembly made a recommendation that there should be an elected governor for each province. Later on, it boiled down to accepting a nominated governor for the province. They said that if a governor is elected from the province, Jawaharlal Nehru was against it. Many members were against it. If a governor is elected, he will be elected by the whole adult franchise, by the whole population, whole electorate of the state. And who will be the chief minister? He is a person elected from a constituency. Who will be bigger? Governor will boss over the chief minister. Is it a presidential system, or is it a gubernatorial system, or is it a parliamentary democracy we are going to have? And as per Justice Krishna said in Shamsher Singh's judgment, to cite the riverine imaginary, it is Thames and not the Potomac that fertilizes the Yamuna. So we have adopted a parliamentary democracy, and elected governor recommendation or the draft was done away with, and we had the nominated governor. That was the draft Article 131. So a nominated governor means, and an elected council of ministers with chief minister as its head means, nominated governor will have limited functions. He is akin to the constitutional monarch of England. The constitutional monarch of England reigns and does not rule. The king can do no wrong. And why a king can do nothing wrong? Because king has no discretion. It is jokingly said that not even in the selection of his bride he has a discretion. So when king can do no wrong, the constitutional office is placed as a paramount pursuant. Governor, president, they do no wrong. They do not have much discretion except for the governor as by and under the constitution. So this is the constitutional edifice our constitution makers imagined. You have a governor who has a role to play, who is a sentinel of the constitution, who takes oaths to preserve, protect, and defend the constitution, a president who takes oath, and they have to act on the aid and advice of the council of ministers. But they do have certain powers, even president, certain powers, which R. Venkatraman famously said, they are compared to an emergency lamp. When an emergency situation, the power goes off, the lamp comes to light automatically, and the power supply returns, the lamp goes off. Next one, please. So this is the, now in Gulati Institute, I should not go to the political federalism first. So let me start with the fiscal provisions. Why our constitution is federal or even quasi-federal? We have a very important mechanism of finance commission under Article 280 of the Constitution. This is an arch or keystone of federalism of India's constitution. Even United States of America, which is an example of a tight mold federalism, does not have a body like our Finance Commission, which recommends to the president a prescribed share of the taxes that has to be distributed to the states. And they recommend to the president. That is not voted in parliament. It's a union executive which aids and advises the president. And president is bound by the aid and advice of the Union Council of Ministers. So what if the president says, I will not accept the recommendation? Benegal Narasimha Rao, who was our constitutional advisor, in his book, The Constitutional Problem in India, he wrote that if any such president is advised by the Union Council of Ministers that you don't accept the recommendation of the Finance Commission, president has no discretion or option but to resign. This is the strongest word he used. Because president is not only president elected by the union, he is a president elected by the states too. And such a president can again be elected with the support of the states. That's a different political scenario he was comparing. And can that president and the union jive well? No. So president has to accept or the Union Council of Ministers shall not recommend to the president to reject the recommendation of the Finance Commission. But we have seen cases where certain minor recommendations of the Finance Commissions have been not accepted. But the tax devolution or the tax distribution proposals have always been accepted. Finance Commission's role has been changing, and they have important reflections on the federal polity. The uniform deficit targets, conditionalities for devolving grants. In this institution, we have discussed them much. So a finance commission, when it becomes a vehicle of implementing the union's current policy of current fiscal policy, and sometimes deviating from Article 275 and 280, placing conditionalities on the states, then the golden role of the finance commission in federal polity becomes less and less. As one famous commentator said, finance commissions, which are to be neutral arbiters, they can only bark at the center, but they can bite the states. That's not good for a healthy federal polity. So finance commission is one of the bodies which is supporting the federal nature of our constitution. Next. Our constitution that way is fiscally federal. Now, we have just seen the discretionary power of the president. If the Union Council of Ministers aids and advises the president, he or she cannot go or deviate from that. So if the Council of Ministers says the recommendation of Finance Commission of 41% should be 31, president will have no option. But such a thing has not happened, and such a thing shall not happen as per constitutional advisor noticed. So now, there was an important debate. Normally, the members used to debate, Dr. Ambedkar used to reply, and the president used to put the amendments to vote. But on one provision of the constitution, on the now the present article 54, 74, that is 51, the draft article, I think, if I am not mistaken, subject to correction. President, there shall be a council of ministers with prime minister at its head to aid and advise the president. So Rajendra Prasad was asking Ambedkar, where in the constitution it is said that the president is bound by such advice? There is a council to aid and advise. Does not the president have the discretion? Ambedkar vehemently disagreed with Dr. Rajendra Prasad, and Dr. Ambedkar and Dr. Rajendra Prasad had a debate. They said that in the instructions in some schedule of the draft constitution, that president shall act is there, but that instruction did not become part of the constitution when it was framed finally. There's in the draft it was removed. So president, it was not explicitly stated in Article 74 or in Article 164 that Article 163 that president or the governor shall act in accordance with the advice given by aid and advice given by the Council of Ministers. But as per the 42nd Amendment, which was brought during the emergency in 1976, Article 74 was amended stating that president shall act in accordance with the aid and advice of the Council of Ministers with Prime Minister at its head. Such an amendment was not brought in Article 163. So Article 163 and 174, though the intent is clear in the mind of constitution makers, it was differentiated with 42nd Amendment. The 44th Amendment, when Shanti Bhushan, the veteran lawyer, was law minister in the Janata Party government, another amendment was brought. President will have the right to return a recommendation to the cabinet and require reconsideration. But if the cabinet reconsiders and say that our original recommendation stands, President shall act in accordance with the aid and advice. Such a provision is not there in 163. But governor as well as the president, in under normal circumstances, shall act in accordance with the aid and advice of Council of Ministers. Where do the discretionary powers come into play? Next one. The discretionary powers come into play. Shamsher Singh's case I have already mentioned. Shamsher Singh's case has very clearly said that governor has to act in accordance with aid and advice of Council of Ministers, except when it is explicitly stated in the Constitution that he has a special responsibility or a discretion. Now, the discretion has to be explicitly stated. An important case came in summoning and proroguing of the assembly. It is governor who is summoning and proroguing the assembly. Under the Government of India Act 1935, as well as in the original constitution draft, it was governor in his discretion. President was never in his discretion. Later on, the word discretion was removed after the Constituent Assembly debates. So, summoning and proroguing of assemblies under normal circumstances, governor has to act in accordance with aid and advice of Council of Ministers. In Tamil Nadu, in 1974, when Speaker adjourned the Assembly Sine Die, Speaker was in the camp of M.G. Ramachandran when M. Karunanidhi was the Chief Minister of Tamil Nadu, and Karunanidhi's government advised Governor K.K. Shah to prorogue the Assembly, and K.K. Shah accordingly prorogued the Assembly. Speaker went in a writ petition. K.A. Madhiyalakan. In K.A. Madhiyalakan versus Governor of Tamil Nadu and others in 1974, the Madras High Court unequivocally held that governor has to act in accordance with the aid and advice of Council of Ministers. Years later, in Arunachal Pradesh, when governor preponed the date of the meeting of the legislature and asked and determined the agenda of the legislature, that is, no confidence motion against the speaker has to be taken as the first agenda. The Supreme Court in Nabam Rabia versus Deputy Speaker of Arunachal Pradesh in 2015 unequivocally held that it is not governor's business to override the aid and advice of Council of Ministers in summoning and proroguing of the Assembly. He has to go by the aid and advice of Council of Ministers. Also, he stated that governor cannot determine the agenda to be taken in the Assembly. Supreme Court used a word that governor need not be the marshal of the State Assembly. A similar thing has been held in Rameswar Prasad versus Union of India, wherein Bhutta Singh's action in dissolving the Bihar Assembly after 2005 elections in Bihar, no party or combination secured a majority. After weighing pros and cons, ultimately Governor Bhutta Singh, who was a veteran politician, who was a union minister, also recommended dissolution of the Assembly. Rameswar Prasad and others went in a writ, and Supreme Court held that the dissolution of the Bihar Assembly by Governor Bhutta Singh, citing reasons of likely horse trading, is unconstitutional. It is governor's job to secure a government for the state, but it did not restore status quo ante. So these 3 or 4 case laws have abundantly clarified that insofar as the legislature summoning and proroguing, the discretionary powers of the governor are limited, and the discretionary powers of the governor are to be explicitly stated, and there is no prerogative of the general discretionary power. President has none, the governor operates on a limited right. Next. But there are discretionary powers. Appointment of a chief minister. I'm not going exactly by the PowerPoint now. In appointing a chief minister and a prime minister, the president, the governor or the president, they have a discretion. When a single party secures absolute majority in the parliament or the assembly, there is no discretion. He has to invite the leader of the party to form the government. In a situation where no party has secured majority, there is a single largest party, there is a pre-poll combination, there is a post-poll combination. How do the president or the governor, how does the president or the governor decide to call whom to form the government? Now, the discretion is exercised to examine who is the best person who is likely to command the majority on the floor of the house. That has to be the thing. President R. Venkatraman had a principle to invite the single largest party first. This is called the Venkatraman principle by T.R. Andyarjuna in President and the Precedent, his article in the Hindu at that time. In 1989, the Congress party, which was in power under Prime Minister Rajiv Gandhi, lost the election. But Congress, which had 404 seats in the Lok Sabha elections of 1984, got reduced to 196, still the single largest party in Lok Sabha. Janata Dal, led by Vishwanath Pratap Singh, who was earlier minister in Rajiv Gandhi's government with 143 seats, was the second largest party. Janata Dal, or the National Front, Janata Dal, DMK, the Telugu Desam, the Assam Gana Parishad, that was a National Front, was standing on two stands with outside support of 88-member BJP and some 52 members of the left parties, including the communist parties. Together, they had a majority in the Lok Sabha. Whom to invite first? Veteran socialist leader Madhulimaye stated that it is Janata Dal who should be invited because VP Singh is the person who is likely to command majority. But Venkatraman, the copybook president, as he used to be described, he was also a veteran politician, was finance minister, defense minister, minister in Madras. He invited Rajiv Gandhi. But Rajiv Gandhi declined. The incumbent party, which was defeated, he said, I am not going to form the government. We are sitting in the opposition. The controversy did not blow. VP Singh was invited. The rest is history. I mean, I'm not into that. Now, in appointment of a chief minister, governor has a discretion. Recently in Maharashtra and Karnataka in 2017 and 2019, we saw instances. Earlier in center also we saw instances. Shankardayal Sharma in 1996 followed the Venkatraman principle. Atal Bihari Vajpayee was the leader of the Bharatiya Janata Party with 152 or 160 members. I'm not exactly sure. Far away from the halfway mark, but leader of the single largest party. He was invited to form the government. Vajpayee accepted the invitation to form the government. In 13 days, the government fell because regional parties, the left parties and others, they had formed a united front. With the outside support of the Congress, they had a majority. Finally, after 13 days, H.D. Devagowda had to be invited to form the government. Likewise, in Karnataka in 2017, B.S. Yediyurappa, the leader of Bharatiya Janata Party, was asked to form the government, invited to form the government by the governor. Yediyurappa's BJP had 105 seats, some 10 or 11 short of halfway mark of 115. I'm not exactly sure. It's 9 to 11 some seats. Yediyurappa's government also fell within a week. He couldn't get the confidence vote. H.D. Kumaraswamy, which formed a post-poll coalition, Janata Dal and the Congress, they formed the government. Again in Maharashtra, Shiva Sena, which was an ally of the BJP, broke away from the BJP demanding chief ministership, and they formed a coalition of NCP, Congress and Shiva Sena. That government fell later. I'm not going into that. Governor invited Devendra Fadnavis of the BJP to form the government. That government fell within a day or two. It couldn't get the confidence vote. And the post-poll coalition formed the government. Punji Commission, Sarkaria Commission, Venkatraman principle, everything boils down to stating that a single largest party's leader should be invited to form the government. They have not been able to form stable governments, and that principle has proved wrong practically. And post-poll combination, if it can command a majority, they should get a precedence over that. So president and the president, president and the governor, there needs to be some corrections. So this is an area where governor or the president, they have a discretion when nobody has a majority. That discretion have been rightly exercised, wrongly exercised in many other ways. So this is one area of discretion which they have. Article 75 and Article 164. Next one, please. This I have already said. Now, one second. There are various governors have acted differently, whether it is due to partisanship, Whether it is due to personal viewpoints, I do not know. In Kerala 1957, the Communist Party of India, which are not split then, got 60 seats in the 126 member assembly. The majority required was 63 plus 164. There were 5 independents who contested with Communist Party's support, including Justice retired V.R. Krishna Iyer, A.R. Menon, and was a doctor. The 5 independents were there. They, together with the independents, the communists had a majority in the Kerala Assembly, 65, 2 more than the actual required. If speaker is elected, 64, 1 more than that. It's a wafer thin majority. Governor was Ramakrishna Rao, who was earlier Chief Minister of Telangana, a veteran Congress leader, learned person. He, before inviting EMS Namboodiripad to form the government, Governor wanted each independent to testify before him that I am going to support the government. Then only the governor invited EMS to form the government. And before the swearing in was there, governor appointed the Anglo-Indian member of the assembly in his discretion. Anglo-Indian member nowadays is not there. A member of the Anglo-Indian community to be represented has to be on the aid and advice of Council of Ministers. But even before the Council of Ministers could be sworn into aid or advice, governor had appointed the Anglo-Indian member, giving one more vote advantage to the opposition. So this was what happened in Kerala in 1957. Diametrically opposite thing happens in Rajasthan in 1967. Congress was the single largest party. Sambhurna Anand, who was earlier Chief Minister of Uttar Pradesh in the 1950s, was the governor of Rajasthan. Together, the opposition Samyukta Vidayak Dal, the joint legislature party, they had a majority. They went to Raj Bhavan, they went to Rashtrapati Bhavan, paraded the numbers and all. Governor still invited the Congress party, which had lesser numbers, to form the government. I am not stating it here, but there is an interesting example in Madras, undivided Madras state, which had parts of Andhra, the Malabar, and parts of this Bellary region and other thing, Madras, undivided Madras in 1952. It was the first time the incumbent Congress government failed to win a majority. Chakrabarti Rajagopalachari, who had been Governor General of India, later he became Home Minister, Minister with a portfolio, he was in retirement. Congress leaders in Madras called back or beckoned Rajaji from retirement and asked him to come and lead the party. Rajaji, it is said, he jokingly said that tomorrow when Salem Municipal Corporation, you will not get a majority, will you ask me to be the municipal chairman? Nevertheless, Rajaji agreed to lead the Congress party, which had 152 members in the Madras Legislative Assembly. The combined opposition, which had formed a united front and elected Tangturi Prakasham, T. Prakasham, who was a veteran freedom fighter, had 166 members. It was a post-poll combination, but had 14 members more than the Congress party. Governor Sri Prakasha invited Chakrabarti Rajagopalachari, the leader of the single largest party, to be the chief minister. But the story does not stop there. It is not a precedent. It became a precedent in Bihar later. Rajagopalachari said, I was Governor General of India, I will not contest an election to the assembly. Nothing doing. I will lead the government, I will not contest the elections to the assembly. What was the way out? In the Legislative Council, Madras at that time had a bicameral legislature, like our Rajya Sabha. We do not have a bicameral legislature. In the upper house, people, erudite scholars can be nominated to the upper house. Rajaji was a literature of repute. He was a learned person, scholar, no doubt. He was nominated in that category. On the recommendation of the defeated government to the governor Sri Prakasha, Rajaji was nominated. And as a nominated member, he was elected as leader of the legislature party and was sworn in as the chief minister. Rajendra Prasad wrote to the Prime Minister. Granville Austin, in his book, Working a Democratic Constitution, has narrated this event. Rajendra Prasad told Nehru that this is not a good precedent. Even Nehru did not like it. But Rajaji, nevertheless, was nominated and became the chief minister. This cannot happen in Great Britain. It is Thames which fertilizes the Yamuna and not the Potomac. But Thames did not fertilize Tamraparni in this. Thames did not fertilize any river in Madras state at this, because when Stanley Baldwin and Lord Curzon were, one of them was to be chosen as the prime minister in 1923, the King George V, I'm not sure, King called Baldwin to be the Prime Minister and not Lord Curzon, because Lord Curzon was member of the upper house, the House of Lords, and Stanley Baldwin was member of the House of Commons. In UK, a member of the upper house is never the Prime Minister in recent days. Only a member of the House of Commons or the lower house is the Prime Minister. But India, we have different presidents. We had H.D. Devagowda, we had Dr. Manmohan Singh, we had Rajya Sabha members as Prime Ministers. Nothing wrong in it. Supreme Court has also upheld it. So the Madras state, we had this example. It was repeated in Bihar when B.P. Mandal for the Soshit Dal in 1967. He was also nominated. Another government was formed. 4 days a person was made chief minister. He recommended to the governor that B.P. Mandal should be nominated to the legislative council. Mandal was nominated to the legislative council. Mandal became chief minister and the government fell in 7 weeks or so. So nomination for the purpose of becoming chief minister has been followed in Madras, and this has been stated as a wrong precedent by none other than the then president Rajendra Prasad. There was a litigation in Madras High Court against this by P. Ramamurthy, the late Marxist leader. He fought a writ in the Madras High Court and lost the writ at that time, that a nominated member becoming a chief minister. That is there. In West Bengal, 1968, another strange thing happened. Prafulla Chandra Ghosh was health minister in the government of Ajoy Mukherjee, in which Jyoti Basu was the deputy chief minister. Prafulla Chandra Ghosh along with 17 members defected. A minister has to submit the resignation letter to the chief minister, because a minister is appointed by the governor and on the advice of the chief minister and holds office during the pressure of the governor, subject to the pressure of the chief minister. So, but PC Ghosh wrote a direct letter to the governor resigning. Governor accepted his resignation. Not only accepted his resignation, invited Ghosh to be the chief minister. That government also fell. These are all certain precedents which rightly or wrongly has happened, and excess discretion has been exercised. Worst of all are the last two things which I am going to narrate. In Andhra Pradesh 1984, Nandamari Tarak Ramarao or N.T. Ramarao, NTR was the chief minister. When he was having a coronary bypass surgery in US, Nadendra Bhaskar Rao and some legislatures defected from the Telugu Desam party. He had formed the government in 1983 after a massive win. First time a non-Congress government was formed. Ramlal was the governor. Ramlal was previously the chief minister of Himachal Pradesh. Ramlal, without allowing Ramarao to test the majority on the floor of the house, invited Nadendra Bhaskar Rao to be the chief minister. Hue and cry was raised. President of India also expressed his distaste discreetly. By then, Jnani Sahil Singh and the central government were not doing so well. So, as a constitutional functionary, Governor Ramlal did not allow N.T. Ramarao to test the majority on the floor of the house. The agitations that took place across the country when I myself and Ramalingam were students of college, we know that. But finally, Ramarao was reinstated. He proved the majority in the Legislative Assembly. Governor was proved wrong. Ramlal resigned and left. There are two more interesting incidents in Uttar Pradesh and Madhya Pradesh in the late 1960s. Basavada Gopala Reddy, who was minister in Rajaji's cabinet in 1952 and was also chief minister of Telangana or Andhra, was governor of Uttar Pradesh. Chaudhary Charan Singh, later our prime minister, was chief minister as leader of the Bharatiya Kranti Dal, which had formed a coalition with Indira Gandhi's Congress R at that time. They fell apart because Charan Singh's party did not support the abolition of Privy Purse bill in the Rajya Sabha. So they fell apart. And Charan Singh recommended to the governor Gopal Reddy that dismiss all the Congress ministers from his government, which governor did not do. Governor sought the opinion of the Attorney General. He said that the coalition has broken up. So chief minister who does not apparently have the majority cannot be accepted. But here there is a catch. Charan Singh offered to prove the majority or test the majority on the floor of the house at the nearest possible date. Without giving him an opportunity to do that, governor dismissed his government and brought in the another government. This is stated as a bad precedent because Charan Singh should have been allowed to test the majority on the floor of the house. He might have got the support of other opposition parties and he might have won also, might have lost also, I do not know. There is even a clear incident in Madhya Pradesh in late 1960s. Here also governor was a former politician, K.C. Reddy, K. Chengalvaraya Reddy, who was chief minister of Mysore earlier. There were defections from the Congress party and the government became a minority, apparently. Opposition parties went to the governor and said, allow us to form the government, call our leader to form the government, dismiss this government. But he said, tomorrow the appropriation bill for the education department is coming up for discussion before the assembly. If you defeat the government is out. Why are you in a hurry? Next morning, the appropriation bill was to be discussed in the assembly at 11. Some half an hour earlier, on the advice of the chief minister who has apparently lost the majority, governor prorogued the assembly. Later on, some defectors defected back and the government stood. These are all certain precedents, not precedents, certain examples which should not be precedents or should not have been precedents. I am talking of the pre-Bommai era. Go ahead. Now, after the Bommai era, I will just come to that and wind up that area. After the Bommai era, the majority has to be tested on the floor of the house only. Head count in Raj Bhavan is detested. After Bommai era, these kind of things have become far and few. Now, barring other than executive powers, governors and presidents do have legislative powers too. I will quickly run through because another 10 minutes I have to wind up. Giving assent to and withholding of bills, sending back the bills with a message. Governor has also a power of reserving bills for the consideration of the president. This is under Article 200. Article 200 was draft Article 175 in the Constituent Assembly. In the Constituent Assembly debate, under 175, governor in his discretion could send back bills with a message to the assembly. In his discretion, that word was removed when draft Article 175 was approved by the Constituent Assembly. In his discretion has been removed. Now remember Shamsher Singh's case, which I mentioned earlier. Explicitly, when there is no discretion mentioned, can a discretion be read into Article 200? This is the question. It's a question which is going to come up in the future in many of the states. Now, the second proviso was added, stating that when High Court's powers are derogated from, if there is a truncation or affecting of High Court's powers, governor shall reserve the bill to the president. He has no discretion. If the, as learned AG said, when there is a concurrent list at a state legislation, if you do not want repugnancy to operate, it has to be sent to the president. In 304, in interstate trade and commerce, if a state has to enact, president's permission is required for introducing that bill. But here we are not on those things. A governor can withhold the bill, stating that I kill the bill here and there. I am withholding assent, means the bill is killed. That's called the absolute veto. There is something called the suspensive veto, sending the bill back with a message to the legislator stating that, or the parliament stating that you reconsider this. The third thing is the worst veto. That's the pocket veto. Put the bill in the pocket and just walk out. You neither withhold, you neither assent, you just put it in the pocket. That's a pocket veto. Pocket veto was exercised by Jnani Sail Singh in 1986. The postal bill, which was passed by the parliament when Rajiv Gandhi had a brute majority in parliament, the interception of mails, that became a huge protest. Opposition parties protested. Jnani Sail Singh put the bill in the presidential pocket for 3 long years. That's the only pocket veto in independent India. But absolute veto has been exercised by Rajendra Prasad and Venkatraman once. But there were unique circumstances. Punjab and East Patiala States Union was under President's rule in 1953, and when President's rule is there, the appropriation bill, the budget is passed in the Parliament. But by the time the appropriation bill for PEPSU was passed in Parliament and it went to Rajendra Prasad for assent, the presidential proclamation of under Article 356 itself was revoked. Rajendra Prasad vetoed the bill. Absolute veto. He withheld the assent. It was justified. R. Venkatraman did this in 1991 when the salaries and pension increase for the members of parliament was passed. Amendment bill was passed by the Lok Sabha a day prior to its dissolution. Chandrasekhar government had lost its majority after that. So a day prior to its dissolution when the bill was passed, by the time it went to president for assent, Lok Sabha had already been dissolved and the country was going for general elections. Venkatraman exercised the absolute veto on the bill. That bill was killed. So only on private members' bill, as well as when the Lok Sabha is dissolved, this absolute veto has been exercised. Governors so far exercising absolute veto, I do not know. Pocket veto has been the favorite veto. But is it the discretionary power of the governor or not is the question. In Constituent Assembly debate, T.T. Krishnamachari unequivocally stated that governor can act only on the aid and advice of the Council of Ministers. Benegal Narasimha Rao also said that governor has no discretion in this area. The debate goes on, but the held position is that the word discretion has been omitted from Article 175 draft, and under 200 there is no word discretion. But Supreme Court in Shamsher Singh as well as in Nabam Rabia said, in second proviso, under extremely rare circumstances, as Sarkaria Commission states, when state legislates into list 1, union list, without legislative competence, when fundamental rights are affected, governor has preserved under duty to preserve, protect and defend the constitution, under rare and extreme circumstances can use his discretion, not a wide and general discretion. This is the prevailing view. Next one, please. Now coming to use of Article 356. Article 356, when Gupte, member of the Constituent Assembly, said, Ambedkar said, I perfectly agree with you that it has to be a dead letter. It is neither dead nor the letter. It is alive and kicking in all spirits. 118 times in the last 75 years. To quote Subhash Kashyap, he said, in every state, at least twice a year, constitution breaks down. This is not our democracy. So after S.R. Bommai judgment, it was said that the presidential proclamation is subject to a limited judicial review. In state of Rajasthan versus Union of India, it was held not justiciable. But in S.R. Bommai's case, it was held that presidential proclamation is subject to a limited judicial review. The aid and president, while dismissing or while taking over the administration of a state and handing over to the governor through another order, acts on the aid and advice of the Council of Ministers with Prime Minister at its head. So, the aid and advice of the Council of Ministers cannot be called into question in a court. But the material on which the presidential satisfaction is arrived at is subject to judicial scrutiny, whether it is malified or whether it is extraneous to the decision, that is subject to judicial review. That did the trick. After that, this wanton declaration of proclamation under Article 356 or have come down. K.R. Narayanan was the first president who returned 2 recommendations of the cabinet to declare president's rule, proclaim president's rule. One in Uttar Pradesh in 1997, when Kalyan Singh ministry, they could win the vote of confidence, but a huge violence in the assembly, chairs flying, everything. So also in 1997 in Bihar, citing law and order breakdown, Sundar Singh Bhandari, the governor, recommended, and the cabinet recommended to K.R. Narayanan, he returned the proposal for reconsideration. Had the cabinet sent back the proposal, K.R. Narayanan would have been bound. But on 2 occasions, one the United Front and next the National Front government headed by BJP, they did not return to K.R. Narayanan. They will to K.R. Narayanan. But Lal Krishna Advani was Home Minister and Deputy Prime Minister, made a strong statement that if Article 356 cannot be invoked now in the case of Bihar, why should it at all remain as the text of the Constitution? But K.R. Narayanan refused to oblige. In Janata period as well as in Congress, in bulk, state governments were dismissed because in the Lok Sabha election, the parties had lost the majority. I am not going into that because nowadays those things do not happen. I am not going into the details of that. But it is S.R. Bommai, which is the result of Karnataka's dismissal. S.R. Bommai, Janata Dal government faced defections from his party, and Bommai was not allowed to test the majority on the floor of the assembly. Governor Venkata Subbaiah, who was Union Minister of State for Home earlier, a Congress politician, dismissed S.R. Bommai. S.R. Bommai's government, Meghalaya and Nagaland, all the 3 dismissals were held as unconstitutional by the landmark judgment of the Supreme Court in S.R. Bommai in 1994. After Bommai, things have changed. Pre-Bommai and post-Bommai, our constitution and exercise of 356 has been quite different. Next one. Now, emergency provisions are one, when they are in operation, the constitution perfectly becomes unitary. Under Article 352, you know, we had an emergency thrice in 1962 after the China War, in 1971 after the Pakistan War, in 1975, citing internal disturbances, Indira Gandhi's 19 months long emergency. So that's one experience. And Article 352 and the amendment, I will quickly run through that. In Article 352, President has to act on the aid and advice of the Council of Ministers with Prime Minister at its head. But Fakhruddin Ali Ahmad on the midnight of June 25, 1975, signed the emergency proclamation. He was not advised by the Council of Ministers with Prime Minister at its head. He was advised by Prime Minister Madam Indira Gandhi. Next morning at 8 o'clock, the cabinet meeting was convened and ministers had woken up to the fait accompli that an emergency is operation in the country. Not a single protest was heard. This is what India Today, much later, under right to information they have gathered and they have disclosed in 2011. So when 44th Amendment came, they said that President can declare emergency only when Council of Ministers convey their advice or decision in writing. What happened in 1975 is no longer possible today. Tomorrow, I don't know. Today, it is not possible. Another emergency is Article 360, which is a financial emergency where governor has no role. If president is satisfied that the financial prosperity demands or credit is threatened in whole of India or any part of India, financial emergency can be declared. When financial emergency is declared, the federal constitution loses its essence. Every money bill passed by the assembly has to go for presidential assent, mandatory. President can reduce the salary of personnel, including High Court judges and in Supreme Court judges. Their salary can also be reduced. President can also request that every bill which has a financial implication has to be reserved to him. Constitution is no longer federal. 354 is another article where during an emergency, the tax sharing arrangements with the states can be suspended. Under 359, the right to life and liberty, the right to move to the courts for enforcing right to life and liberty can be suspended. Right to enforce fundamental rights can be suspended, but 44th Amendment saved right to life and liberty. Because in 1976, in ADM Jabalpur versus Shivakant Shukla, H.R. Khanna sarcastically asked the Attorney General Niran Dey, if a drunken constable shoots a citizen on the road by mistake, can the court intervene? He said, no, Your Honor. At that time, right to life was not enforceable in an emergency. Now, right to life and double conviction for the same offense is, if you can move the court. So these are the drastic emergency provisions. Next one, please. I am now concluding. The evolving views of the judiciary in the Aadhaar case, minority views have been upheld. In Eke Gopalan versus State of Madras, if a law has a proper procedure without following due process, liberty could have been divested. But now right to life and liberty has been held as predating the constitution. Constitutional interpretation in different political environments had got different impacts. Constitutional Functionaries Act has aided and abetted the strong unitary features. Constitutional functionaries have also upheld federal principles, just as I cited K.R. Narayan. Views of the judiciary which says that if there is cooperative federalism, there can be uncooperative federalism too. In the recent judgments in Mohit Minerals versus through its director, that's a central excise case where GST people have been discussing. I am not on the GST angle, but they said that contestations between union and the state are also important in a democracy. So the evolving views of the judiciary have left the situation ambivalent. Nevertheless, whatever be the written safeguards, written pitfalls in the constitution, the traditions and conventions evolved by constitutional functionaries can make a constitution, can mar a constitution. We have made our constitution function. Our democracy has been vibrant. It has been agile despite its fragilities. And that is how our constitutional functionaries have displayed their role. Thanks a lot for the patient hearing, and I apologize for crossing the time limit. Thank you.
Whether honorable chairperson is there. Can you remove that and see whether? No, it's fine. 40 minutes, just 40 minutes. I was wondering whether Honorable Advocate General is available over there.
Yes, I am here.
Very much. Okay, over to you, Chairperson. I think we would like to have your, you have the role of not only the chair and the discussant, I suppose, but yeah.
Now we can conclude the session with the permission of all. Can we conclude? Am I audible?
Shall we have with your permission, we shall have a few questions. You may
Yes.
keep the floor open. It's your.
Definitely.
Yeah, I think it's also getting late in the day. I'm sure it was a very illuminating and highly informative presentation covering various aspects. Otherwise, normal economy student may not be knowing. I really felt, economics is nothing but political economy as it originated. And today I understand, today the major takeaway for me is I was gifted a copy of the Indian Constitution by Professor M.V. Pali long time when I was in JNU when I met him. So I'm going to start reading that. That's going to be the takeaway from my side, this thing. And I think I'm sure our youngsters will have questions, please. Yeah, few questions. I think Honorable Article General also has to leave. Few questions we can. Yeah, experts. Yeah, right.
Thank you, Mohanji, for the excellent presentation. I have one question regarding the, you explained that the tax sharing liability can be suspended, no? Actually, in which are all this, times or whether it happened? Is there any, would you please explain the, the provision in that? And because we are interested that, whether it happened in India or in some places, and which are the occasions?
Mohan, I have to answer or you will be?
No.
I will collect the
I
questions.
think perhaps you start answering by the time
Yeah.
other questions will
The
get.
article which Anita was asking is Article 354. That when an emergency is declared under Article 352, provisions from Article 268 to 279 can be suspended. 280 is not suspended. Tax sharing is under 270 in that area. So tax sharing arrangements can be kept in abeyance during an emergency and till the expiration of that financial year. Even during 1975 emergency, this has not been put to practice in India, but that power is available under the constitution for the union government. This 354 is the article.
Only in abeyance, but can be.
During the period of
resolved.
emergency,
Yeah.
that's all.
That is why, during the discourse here that we had on fiscal federalism and COVID-19, so many people highlighted the possibility of an economic emergency, and that should be averted at any cost. That was the major, just in the April when we had the discussion. Yeah. So.
Sir, I have one question, but I don't know whether this will fit into the discussion. There is GST Council, that is Article 279A, which says that the GST Council role is to have a recommendatory nature. How far, for example, the finance minister of any states goes to the GST Council, get the recommendation, come back to the legislature, and the legislature has strongly opposed that thing, and it passes in the legislature, whether it can be a part of the state GST Act. Then there will be a contradiction from the central GST Act and state regarding the rates, regarding the procedures, etc. So even though latest case of against that, just forget about the white mineral case also, having said that it is only a recommendatory nature. Never it has happened now, but it may happen in the future when there is a coalition government at the national level. So I need the opinion from the honorable member, Advocate General also from this area. Thank you.
See, Sir can also give his opinion, but here, let me say that in a federal setup, as Leonard Advocate General had said, Article 246 is the power which is divided between the center and the union and the states. But taxation as a subject, including GST, has or is never on the concurrent list. It is in the union list and the state list, as Ramalingam eminently knows it. So it is GST Council cannot be a supra-legislative body. That is why the GST Council's adjudicating committee itself was disbanded when from the bill it became an act. The Supreme Court judges adjudicating committee was not implemented. Now the point is, it is recommendatory, but in effect, if a state deviates, there are practical consequences in interstate trade. But repugnancy may not operate, but there are practical consequences in interstate trade. And a state in the present setup may not be able to practically afford to deviate, but theoretically or constitutionally it can.
So would you like to supplement anything that you think that is the
I
way?
agree with Mohan what he has suggested. I think that even in spite of the pronouncement by the Supreme Court, none of the states have resorted to reduce the rates or vary the rates with that of the decision of the GST Council as present advised. Probably.
Please.
I think this is only a clarificatory question. No, you mentioned that the precedent, there are, for different issues, different precedents are there. But is there any constitutional amendment required for changing the precedent, or we can?
See, I'm not a lawyer, but all events that happen cannot be precedents. A precedent is something which is followed, but in judicial system, you have binding precedent and other things. In constitutionally, there's no amendment is required. Certain things are cited as precedents if they are rightly decided and they hold the field for long. But an aberration can never be cited as a precedent. Rajagopalachari's nomination in 1952 cannot be cited as a precedent, and after that nominated members have not become chief ministers except Mandal's example in Bihar. So this Ramlal, what he did in Andhra, had Bommai not been there also, it is not a precedent. Every British constitution, UK's constitution, the unwritten constitution is wholly based on precedents. A precedent has to be, William III in 1692 exercised veto power of the legislations passed by the parliament. But after that, Queen Anne exercised it once, but in the last century, the royal veto is an unheard of thing in UK. So whatever is done in the past is not a precedent. Occasionally, certain things in the absence of provisions, they become precedent. But no constitutional amendment is required. This is what I feel.
So I would like to ask it's a clarificatory question. So with the passing of National Medical Commission Act in 2019, the NEET has become NEET has become a mandatory exam. It's not like optional. It has become mandatory. But what about the statute? The validity of the present anti-NEET bill that was proposed in Tamil Nadu, which has been provided to governor, which has been referred to president actually now.
Rejected already.
Tamil Nadu rejected the NEET examination.
I think Tamil Nadu Assembly passed a bill. It is again a case of pocket veto. I am not exactly sure. It is again a case of pocket veto. Governor just put it in his pocket. There was also a writ petition filed, and Justice Kripakaran had mentioned that constitutional authorities we expect constitutional authority to act in a constitutional manner, and said extraordinary situation needs extraordinary remedies. It has gone for presidential thing. I said now. Readopted it. If Assembly readopts it, as per Article 200, Governor is bound by that Assembly. You can ask Leonard Regis here to supplement.
It's only if it's a case, it is returned by the governor. Then again, you can reconsider it and send it back. There is no option but to give us it. Here in this case, that only one case wherein the giving of assent was challenged or issue of mandamus was sought in a court is that the case which now referred by Mr. Mohan. The NEET case, I think the original Preeti Srivastava judgment, wherein it is said that the being, since it relates to the higher education and standards of higher education, whatever be the state legislation which comes under Article 25, item 25 of the concurrent list, the other legislation will prevail because of provisions of Article 254. In that fashion, it was settled as early as in 97 or 98. 1998, I think the regulation of admission, entrance examination, and the mark gradation list and the admission control by the NEET entrance was upheld by the Supreme Court when it was challenged. I think it was covered by the Preeti Srivastava's case in 1997. It was held that the entry 66 in list 1 is with reference to the higher education, coordination, standards of higher education, etc. But entry 25 in concurrent list is only with reference to education, medical, and other subjects. My friend was referring to the NEET entrance examination and regulation of admission to the medical courses by in the light of the results of the entrance examination. Am I correct?
Yeah,
Yes, sir. Yes, sir.
that's okay. Ranjit, yeah, please.
One small question. So this is regarding the recent issues which is going on in few states in few southern states, Kerala, Tamil Nadu, and Telangana. Some bills are parked in governor's office. So my question is, like, this is also affecting central-state relations. How long will it go, or at which juncture the president can intervene this issue?
See, let us look at the constitutional framework and not individuals who are manning the post of governor. Let us see. President, when he comes and intervenes, it's not the president who intervenes, but the Union Council of Ministers on whose aid and advice the president acts. What does Article 356 say? President has to be satisfied that the administration of the state cannot be, affairs of the state cannot be run in accordance with the provisions of the Constitution. Ambedkar was very clear that maladministration, corruption, they are not reasons for presidential intervention. There are people to look at them. Now, president can, or the Union Council of Ministers can advise the president, and president can derive his satisfaction or her satisfaction based on the report of the governor or otherwise. Governor can send a report that constitutional machinery has broken down. Ramakrishna Rao did here. In 1954, Andhra. In 1951, in Punjab, a very strange thing happened. It was a Congress government run by Gopi Chand Bhargava, and Jawaharlal Nehru was prime minister. There was a dispute over appointment of ministers between the Congress High Command. Nehru was also Congress president. Granville Austin has written extensively about it. Now, G.C. Bhargava had his own views and he refused to accommodate certain ministers. Finally, he was compelled to resign. And Article 356 was imposed in Punjab in 1951, and it ran for 1 year to resolve an intra-party tussle. Rajendra Prasad expressed his distaste and discontent, but it was agreed upon. Now, a president's intervention after Bommai's case, it has to be rare and in extreme cases, and President K.R. Narayan has also set the precedent. In Tamil Nadu in 1991, another strange thing happened. Governor Surjit Singh Barnala refused to send a report stating that constitutional machinery has broken down. M. Karunanidhi was chief minister. It was the opposition ADMK which was supporting Chandrasekhar government, and the pound of flesh was asked. But Chandrasekhar's principal secretary has denied it. Whatever that be, not entering into the political controversy, Governor Barnala did not send a report. R. Venkatraman, president, used the otherwise clause of Article 356 and dismissed Karunanidhi's government and dissolved the assembly. Later on, Rajiv Gandhi's assassination and other things took place. Now, president's intervention and the controversies or conflicts between which is happening in the press, they have no connection whatsoever. If a governor sends a report and president arrives at a satisfaction, which of course is now subject to judicial review, how president arrived is satisfaction. President can act. President can act otherwise also. Subject to parliamentary approval within 2 months, extension, everything. 356 is clear in that. So what is happening in public domain and presidential intervention, a nexus need not be drawn by us. This is my view, can be wrong.
Sir, perhaps you may have view on it, and we can
No.
brief, and we can conclude with that.
Now the question I think is with reference to the withholding of the bills ordinances sent by, can such a situation lead to the intervention of president? Am I correct? The question was to the effect that whether the present situation by a constitutional functionary withholding the bills sent for assent or the ordinances sent for assent, in such a situation a president's intervention is warranted. In our constitutional scheme, I think that so far as the withholding of the bills are concerned, or the legislative acts which have been sent for the assent of the governor is withheld, in such a situation, there is no warrant for the interference of the president in the scheme of our constitution. There is only one instance in judicial decision reported. One can see that is that a case from Kerala where that was only on the limited question that whether a act passed by a legislature sent for assent can be sent to the succeeding house for being considered as when it was returned for consideration by the governor under in his discretion. So for under Article 200 of the Constitution, that was the only decision wherein the court held that there is no time limit prescribed, and it was also held that it is not necessary that same house should reconsider it when it is returned by the governor after consideration. That is the way it has been. And the other case with reference to the act passed by the Tamil Nadu, which a petition was filed before the Tamil Nadu Legislative Assembly, wherein it was withheld by the governor, and the direction by the observations by the High Court in that case that it is a constitutional obligation and it should be done. And it gives several persons in the downtrodden section to have admission to the higher education system and all that. That is the way it was dealt with, I remember.
Okay, I think shall we conclude then? I think I'm sure as it is going to be officially stated by the concluding statement from our coordinator. This has been a highly enlightening evening, and I once again extend our invitation to Honorable Advocate General to please physically visit us, and we will be extend you. This is an open invitation at your convenience.
Thank you. I will make use of the first opportunity to be there.
Thanking you is my coordinator's job. If I enter into that, that will be a judicial problem there. So over that to you, the coordinator. That's right.
Thank you, sir. Good evening, everyone. On behalf of GIFT community, I would like to place on record our sincere thanks to Advocate General Shri Gopal Krishna Group for taking time out of your busy schedule and being with us today. Your introductory remarks on constitutional provisions for center-state relations are extremely useful, and we have learned a great deal from you, sir. We simply can't think of a better chairperson for today's lecture. Thank you once again for being with us. I would like to thank the speaker of the day, Shri R. Mohan, for his excellent overview. As director has already mentioned, that being the students of economics, a lot of what you have spoken today is completely new, and it is very educating and enlightening for us to experience or to listen to your excellent overview of the center-state relations and the political economy behind that. Thank you, sir, once again for your lecture. Now, I would like to thank our director for his continued support. I would like to thank my fellow coordinator, Dr. Anup Kumar, for all his support in organizing this event. I would like to thank our team member in the seminar committee, Vrinda. She has been very active and she made the entire process very, very seamless. I would like to thank our fellow faculty members and students, and also those participants who have joined us online today. Thank you very much for joining us. And last but not the least, I would like to thank our excellent IT team, who always makes these gift webinar series seamless and very, very successful event. Thank you one and all. Until we meet the next Friday, this time our very own PhD student is going to be presenting on November 18th. So look forward to seeing you and welcome you again.